Welcome to Civil Justice for SA Survivors.
Welcome back to Civil Justice for SA Survivors with attorneys Marc Pearlman and Melissa Anderson. Marc and Melissa represent survivors of SA or sexual assault and exploitation across Illinois, guiding them through the civil justice process with compassion and clarity. I'm Chelsea, and today we're talking about whether a civil lawsuit may still be possible when physical evidence no longer exists. Welcome back, Marc and Melissa.
Thank you,
Hi, Chelsea.
Does a civil SA case automatically become more difficult when physical evidence no longer exists?
I think it depends on how you go about approaching the other side in terms of trying to work with them to see if you can resolve a case. So obviously, if you're in court, evidence is very important. And often there with SA cases, civil cases, there isn't physical evidence. So, and that's understood that when you're going and immediately litigating a case, that might be a hurdle. It doesn't make filing a lawsuit impossible, but I think it's ideal to try to approach the other side about seeing if there's any alternative ways that you can try to work through a claim and resolve a claim without first going to litigation. And from our experience, a lot of institutions have been amenable to doing that for several reasons. I think it's less expensive for these institutions to try to work through claims without immediately paying for lawyers to prepare a case for trial. Even the discovery process and gathering evidence can be very costly for both sides. So when you're handling a claim more informally, where you're voluntarily providing document exchange to the other side and sharing openly what it is that you have in terms of evidence, whether or not you have sort of a smoking gun or something physical that will, prove that the SA took place, that becomes less important if you're handling a case that way. There's ways around that if you are going to litigate a case and go to trial, but it's often what we recommend is that we try to do that more informally at first to see if a resolution can be had without going to litigation and being in court.
In most SA cases, regardless of when it occurred, there is not often physical evidence, number one. Number two, typically there's no witnesses, right? These are crimes that typically take place in private where it's just the perpetrator and the victim. So while physical evidence, what I'll call direct physical evidence, is not always available, it also isn't necessary. Like there's ways to establish your crime and what happened to you without physical evidence.
How does the burden of proof in a civil case affect what evidence is needed to move a case forward?
Well, with regard to the varying burdens of proof with civil and criminal, there's a heightened standard with criminal cases. So often when somebody goes to the police and wants to pursue sexual assault criminally, oftentimes they run into roadblocks where the police and the state's attorney just say that there's nothing they can do. And there's the burden isn't as strict in civil cases. So when they come to us, that's usually their concern right away is the police weren't able to do anything. Does that mean I can't pursue this? And our answer is usually no. There is a much higher standard with criminal cases. So oftentimes pursuing it civilly is the only way that survivors of SA can get any sort of justice and resolution.
And another thing is that in SA cases, it's very unusual that a perpetrator engages in this kind of conduct once. There's typically several victims, and because of that, there may be a like a course of conduct or evidence that suggests that they had a particular MO in how they approach their victims. So often that's very, very powerful evidence.
If physical evidence is unavailable, what kinds of records can help establish that abuse occurred?
Right. So thank you. That's exactly kind of what I was getting at. And it may be that if an institution keeps accurate records, if there were complaints or inappropriate conduct, not only is that often in the employment records, and if it's not directly in the employment records, there's an indication in the employment records by where you can tell they're they're ignoring the elephant in the room, if you will. Um, and that's very, very powerful evidence because it shows both from an institutional basis, knowledge and awareness of a problem.
And, oftentimes institutions intentionally don't keep records of certain things despite their own policies to retain records, especially involving claims of SA. We've seen it in cases involving SA with children, and an institution will say, no, this is the first time we're ever hearing about anything like this. We've obtained police records through the Freedom of Information Act in the past, where we will request everything a certain police department has with respect to a perpetrator. And even if charges haven't been filed against the perpetrator, there's still a record of a complaint having been made. And oftentimes there's somebody highly placed at the institution who was interviewed by the police. So that is really strong evidence or support for the fact that the institution knew and just didn't keep a record of it. So that at times we found that to be really helpful in establishing that the institution knew that this perpetrator had been committing SA on their watch.
How important is corroborating information when a case depends largely on personal testimony?
It's important. I don't want to. It's very important. I won't say very important. It's very helpful. I don't know how important it is, but it is helpful if there's corroboration through other incidents, or if somebody's sharing a story about what happened to them and it matches the same story that five other people have told about this perpetrator. um, Typically a jury would be inclined to believe that.
And also there's corroborating evidence that supports that SA took place. It doesn't necessarily point the finger at a particular perpetrator, but for example, corroborating evidence such as school records showing that the victim was in fact at a school when this perpetrator was employed there. And then also things that people don't often think of, but records from the survivor's life showing what their life has been like since the SA. So oftentimes we'll see with a child, for example, almost an immediate drop in grades at school, or no longer participating in any extracurricular activities. Medical records often won't show evidence of SA, but what they'll show is evidence that something has happened to this person right around the time when they maintain that it did. And science is catching up with um, establishing that certain damages are very particular to sexual assault, or especially with children, that the types of problems later in life that we see are almost directly linked to somebody having been subject to SA. So having those types of corroborating evidence, that's often helpful too.
How does the passage of time affect the way evidence is gathered and evaluated in these cases?
Well, it has an absolute effect on it because of the passage of time. Obviously, um, people move on, or people are no longer around in terms of alive even, and and documents may only be retained for a certain period of time. Um, but again, so I'm going to say it has an impact, but I don't know that any of these evidentiary issues are critical to being able to maintain a sexual an SA case. Um, and thankfully, because of the courage of our clients who have, we've been doing this 20 some years, and a lot has changed for the better. Now it's changed at a glacial pace, but it has changed. And because of that, we have judges and juries that are more understanding of what survivors of SA go through and deal with, and why it takes them so long to come forward, et cetera, et cetera.
How do you begin evaluating a case when very little evidence is available at the outset?
Well, really what you're looking, even if there's no real evidence, you look to corroborating things. So you look into whether there's anything publicly available with respect to the perpetrator. So that's how you start to evaluate. You look at patterns in terms of an institution, in terms of handling similar cases, and whether or not similar conduct had been taking place at a particular institution. So really in the beginning, you're trying to see what you can find out about a perpetrator in the institution. Even though there might not be direct evidence of SA, you also start to look into the survivor and what their life has been like. I mean, before you ever file any sort of litigation, you're going to do due diligence in the beginning to see, what can easily be obtained, and that will really frame how you move forward in terms of trying to get some sort of resolution for your client. So in the beginning, you're just seeing what you can find publicly available. Oftentimes, there is a lot of information out there.
We also, over the years, I'd like to think that we've learned a few things, and that we know that survivors of SA have very common issues and characteristics. And so that often helps, that we were able to evaluate on a preliminary basis whether we think this is a credible claim or not, right? And we do that using what we can find publicly, what's publicly available, and then also we evaluate, based on our experience, whether the survivor is exhibiting things that typically suggest extreme trauma, including but not necessarily limited to SA.
And also, the absence of information about a perpetrator, publicly available information about a perpetrator, doesn't necessarily mean that a claim can't be advanced. I mean, there's always has to be the first person to come forward. Perpetrators often don't just do this once, but there is always a first person to come forward. So just because nobody has ever accused this person of committing SA doesn't mean that it's not something that can be pursued for that first person who comes forward. And oftentimes we find that we were able to tell those clients, because you came forward, there's all of these other people coming forward too. They're the ones who put the name out there to begin with, and other people come forward and share that they've had similar experiences. So even if that's not publicly available information at the beginning, once you go public with something with the name of a perpetrator, other people oftentimes come forward and just trickle in slowly, because they feel more comfortable now knowing that they weren't the only one.
And that's why public disclosure of these SA matters is critical, because we can't tell you how many times we've had somebody come forward, we go public, and over the next 6 months, we have 10 other people that have come forward.
What ultimately determines whether legal action is still possible when someone believes evidence may be limited or completely unavailable?
When you say possible, I don't think anything would make it impossible to pursue this if it's a valid claim. When I say valid, credible. And there are challenges and difficulties in terms of evidentiary issues, but none of it is insurmountable. We have done this often and long enough to know that there is a way to prove your case and meet the burden of proof, which is more likely that it happened than not. Um, you know, we've never declined a case because we didn't think there was enough evidence.
Hmm. And it's never just one thing that we're looking at. It's really a totality of a bunch of different factors, which guides us in terms of how we're going to move forward. So, absent something, definitively that's an absolute roadblock, evidence that somebody's, not telling us the truth, which is rare because people don't tend to make this sort of crime up. But it's really just the totality of everything you're looking at, which guides which way you go in terms of handling a claim. So there's not ultimately one thing that goes into that determination.
Well, thank you so much for all of the information, you two. And that's it for today's episode of Civil Justice for SA Survivors with Marc Pearlman and Melissa Anderson. If you'd like to learn more or speak confidentially with their team, visit pearlmananderson.com for resources and contact information. Thanks for listening, and if you found this episode helpful, please subscribe and share it with someone who may benefit from this information.
Thank you, Chelsea.
Thank you, Chelsea.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.